some overview topics and get some beginning level topics out for people. So if you have been practicing for a while, most of this is going to be review for you. If you are brand new to juvenile delinquency court, hopefully this will be helpful to you, because in our travels, some of what we're seeing is different places are having different issues with secure custody hearings. So the focus of this is secure custody prior to disposition, although we may touch on some issues that come up after disposition. One thing too, if you want to put in the chat your years of experience practicing in juvenile delinquency, that helps us for future training purposes so that we know exactly what topics might be helpful and what level that we need to work with for some of these webinars. So with that, I'm going to jump into the topics that are covered here. So we've got just a general overview. We're going to talk about the types of custody, the legal criteria for those different types of custody in the statute, the time frame. So if you have a kid who is in secure custody, what's the maximum duration and how quickly do you need to have your next hearing? And then we're going to talk a little bit about the hearings and orders themselves, what a judge is required to put in those orders. And then the last topics are going to be on shackling and the use of open hearings, because that's something that we typically do see with our secure custody hearings. As many of you know, the kids are brought in already in shackles and chains at the very outset. So just skipping right ahead to the types of custody. The main focus, like we talked about, is going to be on secure custody, but we did want to touch on some of the other types of custody. We don't typically see temporary custody because at that point in a particular case, it's prior to a kid being charged, prior to any petition being filed. But you do need to be aware, just in case you get phone calls from different clients, that there is temporary custody under 7B 1900. It's very limited. It's used until a court can obtain, or court order can be obtained in only the following three circumstances. Law enforcement can obtain temporary custody if grounds exist for arrest under 15A. Law enforcement or a juvenile court counselor can obtain temporary custody if there's reasonable grounds to believe that the youth is undisciplined. Again, we don't typically see those because we're not appointed on the undisciplines. And then by law enforcement or a juvenile court counselor, if there's reasonable grounds to believe the youth has absconded from any residential facility operated by DJJ or from a detention facility. The important piece of that is that it has to be a detention facility that is operated, or a residential facility that's operated by DJJ. Time frame is very limited for those. So if the youth is not being released to a parent or a guardian, they are not to be held for more than 12 hours or 24 hours if any of those hours fall on a Saturday or a Sunday or a legal holiday, unless there's been a petition or a motion for review filed, and then a secure custody order issued along with that. Non-secure custody, and again, we're talking non-secure custody specific to delinquency court, so not in the realm of abuse neglect, but in delinquency court. 7B 1903 covers this, and again, these circumstances are limited as well. Court would have to find that there is a reasonable factual basis to believe the matters alleged in the petition are true, and that the youth is a runaway and consents to non-secure custody, or the youth meets the criteria for secure custody, but the court finds it's in the best interest to place the child in non-secure custody instead. You can utilize this yourself if you have a situation where mom and dad are either not present in court, or they come to court and say, we don't want the child placed back with us. If you're in one of those situations where there's difficulty finding placement for a kid who needs mental health placement, a PRTF, or some other leveled facility, this is a statute to be aware of, because you can ask your court to enter an order for non-secure custody as an alternative to secure custody. And if you do that, you should note that the statute does not provide a requirement for notification to DSS at this point. Now, that's different if you do ask for placement with DSS as a dispositional alternative. There is a notification requirement there, but there is not a specific notification requirement at the secure custody stage. And that brings us to secure custody. So in this specific presentation, basically what we're talking about is, again, prior to disposition, we are talking specifically about 1903, and that secure custody is only to be used if the youth meets statutory criteria pre-adjudication, after adjudication but pending disposition or placement, and then for violations of probation or transportation of youth. That fourth one, if you're talking about transportation of a kid, you need to be aware that the use of restraints is limited there. The statute specifically says that restraints are to be. I'm sorry. Thought there was a question. I'm sorry. So the restraints are only to be used in limited circumstances. If you have a kid who is under 10 and no delinquency petition filed, but there's a need for treatment, restraints are not allowed, but there's some pretty large loopholes there. They can be allowed if reasonably necessary for the safety of the person providing transportation or for safety of the juvenile, and reasonably necessary is in the discretion of the officer or the authorized person. So even though it's not supposed to be allowed, that's a pretty wide open loophole for somebody to walk through. So as far as who has the authority to issue secure custody orders, there are restrictions on this as well. So any district court judge obviously can order secure custody. That's under 7B 1902. Your chief district court judge can delegate that authority by an administrative order. We have seen in some counties that magistrates are signing off on this, but typically the order is delegated to the chief juvenile court counselor or their staff. You need to check with your chief judge to review the administrative order and check for the specific persons with the authority to do a secure custody order, because sometimes they may be signed by somebody who does not actually qualify. And then of course that invalidates the order. So if there is an administrative order in your county, it has to designate the specific person. So if it says Chief JCC and their staff, ideally it should actually say which staff members. And again, if you have a person who enters a secure custody order under that delegated authority, it still has to meet the statutory criteria, which we'll get to in just a little bit. Now, we do have some other statutes that cover this. So 7B 1902 obviously speaks to district court judges' authority, but we also have 7B 2200.5D. If you have kids who are 16 and 17 and they have been transferred to superior court, any superior court judge can issue a secure custody order on remand. Now, if you read that statute closely, it's supposed to be upon request of the prosecutor, which I would argue means that the judge can't order it unless the prosecutor requests it. But most of the time, if you have a situation that crops up like that, where a judge says, I want to order secure custody, and you object on those grounds, then the prosecutor is going to ask for it anyway. So you're probably not going to get very far with that, but just be aware that it's in the statute and still has to meet the statutory criteria. So most of our superior court judges are not that familiar with the juvenile code, so you may have to spend some time teaching a superior court judge. You can't just order secure custody on this. It has to meet these criteria, and then you're having your hearings in a superior courtroom setting. So that brings us up to the statutory criteria, which are under 7B 1903B. Court must find that a reasonable factual basis to believe the youth committed the offense alleged in the petition exists, and that one of 8 statutory criteria exist as well. So the first 6 of those criteria apply specifically to delinquency matters. The last 2 apply to undisciplined matters. Most of the time, we are not going to be appointed on those undisciplined cases. There may be some limited circumstances where that could be different in your specific county, but most of the time, we're going to be looking at the first 6. So for those statutory criteria, the very first one is that your kid is charged with a felony and has demonstrated that he or she is a danger to property or persons. So if your kid has no prior history, you need to consider arguing that has demonstrated does not apply to the current allegations. It's pretty easy for the prosecutor to argue, and they typically do argue, this kid is a danger because they're charged with an armed robbery. Okay, but if it's this kid's first time that they've ever been to juvenile court, they've never been charged with anything violent or serious before, you need to make those arguments, especially if you have a kid who is charged because they happen to be with another group of kids. So make sure you're looking at that and reminding the court of their specific burden in these cases. Simply being charged with a felony should not automatically qualify as being a danger to persons or property. We make that argument all the time in Iredell and Alexander. We don't always win that argument, but try to make that argument anyway as best you can. So the second criteria speaks to misdemeanors. In that particular case, youth has demonstrated they are a danger to persons and is charged with either a misdemeanor that involves an assault on a person or a misdemeanor in which the youth used or threatened to use or displayed a firearm or other deadly weapon. Same argument as before. You need to be arguing that has demonstrated does not apply to the current allegations. And then this one also includes if a kid is charged with impaired driving or driving after consuming alcohol or drugs under 21. I don't see a whole lot of those, but I know some counties do. So you need to, again, be arguing about no prior history. If they do have prior history, if the prior history didn't involve assault or any type of dangerous activity, can still be arguing that this specific child has not demonstrated they are a danger to persons or property. And don't forget to argue about the first portion of it, whether or not there's a reasonable factual basis to believe the petition is true to begin with. So your third statutory criteria, youth has willfully failed to appear on a pending delinquency charge or a violation of probation or post-release supervision. Those all require that the youth has been properly notified. Proper notice is notice in open court or a properly served summons. The youth has to be served individually, so proper notice does not include notice and summons was given to the parent but not the kid. Kid was at school, mom and dad got served, but the kid didn't. That's not proper notice to the child. It also does not include the juvenile court counselor told them when the court date was. So when you're standing in the courtroom and the court counselor pipes up and says, well, I talked to them the other day and I told them that they had court. That's still not proper notice. They have to be served with the petition and with the summons. Probation violations may be a little more tricky on that end because don't get any verification on those. All we have is that they have been mailed out. So you need to look closely at those documents to see when was it mailed. Is it possible that there was some lag time and the kid was not actually noticed? Make those arguments about the willfully failed to appear portion of it. If your kid is 12 years old and they didn't appear for a prior court date, how are they going to get there if they didn't have a parent bring them, if they didn't have a guardian bring them? With my older kids, a lot of times that argument doesn't go so well because the DA will argue back. They're 16, they're 17, they could drive, they could get a friend to bring them, they could do all these other things because they're 16 or 17 years old. Well, if there's no proof that that kid has a driver's license, no proof that that kid has access to transportation, even if they do have a driver's license, and there's no access to public transportation in your specific county, you still need to be arguing the youth didn't willfully fail to appear. So our fourth statutory criteria, delinquency charge is pending against the juvenile and there is a reasonable cause to believe the juvenile will not appear in court. So this kid may or may not have missed a court date in the past. It just says reasonable cause to believe the juvenile will not appear. This is usually whenever the court counselor or the DA or a parent or someone says the kid has run away in the past and we're afraid they're going to run again. We don't think they're going to show up for court. Every single time I have had this situation crop up, it has not been used for a kid who has ever run from court. It has literally been, they ran away from home, so because they ran away from home, they're not going to come to court. You need to be arguing that just because they ran away from home one time in the past or two times in the past, or maybe they've got such difficult issues at home that they've run away from home a lot, does not mean that they won't appear in court, especially if they've got other family members or friends who are responsible and are willing to bring them to and from court. It's a very different set of circumstances for a kid running from home versus running from being brought to a courtroom. I have had a kid that went to school, forgot their court date, everybody's looking at the next court date and saying, we want to put this kid in secure custody because we think they're not going to come to court. Well, they didn't run. They didn't run away from home. They didn't run from the court counselor when the court counselor came to pick them up. They literally forgot their court date one time. And on that one occasion, they were sitting in school, which is exactly where you would hope they would be if they weren't in a courtroom setting. So I was able to keep that child from being placed back in secure custody. But just make sure that you're mindful of those specific issues with your kid and what are the reasons that they have run away from home or from treatment facilities in the past, if that's the only ground that is being argued for, this kid might not show up for court. So our fifth one, the juvenile is an absconder from any residential facility operated by the division or any detention facility in the state or any similar facility in another state. This one I typically will argue absconder and the definition of absconder because it's not clearly defined in the statute, but we do have some good case law for what qualifies as an absconder in the adult system. So if you can utilize that and argue this kid's not an absconder because they weren't willfully hiding from or they weren't absent from this place for a long enough period of time, you may be able to get a judge to allow your kid to be released from secure custody, or at least consider not entering an order in the first place if there's something going on with the residential facility. The other thing that you should look at with these residential facilities is what's actually going on in that facility to begin with. Are there a lot of complaints about it? Has this kid been having particular problems with it and complaining about it? Has the parent, the guardian, custodian, DSS had any difficulty with the facility itself? And do they know where this child is? Because we've had a couple of situations where kids have run from facilities and then later on that facility got shut down because it turned out they were doing some things that were inappropriate. So do look at the circumstances. Is your child truly a absconder, or is this just a situation where they were gone for a little bit of time? We've seen a couple of situations where a kid walked out the front door because they were mad and walked across the street. So they were technically not on the residential facility campus, but they didn't go any further than that. That's, in my mind, that's not an absconder because this is a kid who's calming down or cooling down from something that could have escalated to a bigger situation. I argue every single time that that's not absconding. So the sixth of those criteria that is very specific to delinquency court before we get into the two undisciplined criteria is that there's a reasonable cause to believe the juvenile should be detained for the juvenile's own protection because the juvenile has recently suffered or attempted self-inflicted injury. So the main thing here to focus on is you're looking at the juvenile safety, but it's not enough to say we think this kid is unsafe. The juvenile has to have actually recently suffered or attempted self-inflicted injury. So I don't think this kid is safe because they're running the streets. That's not enough. You have to look at what specific action did the kid take to cause some type of injury to themselves. If that happens, the child has to have been refused admission by one appropriate hospital, and the period of secure custody is limited to 24 hours to determine if hospitalization is needed longer term. The last piece of that is that a physician has to be notified immediately if a kid is placed in secure custody based on this. Ideally, that physician would be coming to the detention facility to go ahead and do an assessment immediately on this kid, given that it's limited in duration to 24 hours. I've only seen this happen once. And in that case, the kid was actually cutting her wrist, but had not suffered a severe injury. And when the evaluation took place, people were looking at it, various different doctors, nurses, detention staff, and said this really was not as severe as what it was made out to be. And the child was ultimately released from secure custody pretty quickly, obviously with directions to have a mental health assessment. But just be aware that a lot of times court counselors and DAs like to ask for this one, saying, well, we don't think this kid is safe because they were involved in this particular incident where somebody else was shot. We're worried that this kid is just not safe because they're not properly supervised. That's not enough. This one is very specific to the child trying to injure themselves. So the seventh one, and again, now 7 and 8 are the ones that are specific to undisciplined petitions. You should not be being appointed on undisciplined petitions because IDS will not pay for those. However, if you are, the statutory criteria here is that the juvenile is alleged to be undisciplined by virtue of being a runaway and is inappropriate for non-secure custody or refuses non-secure custody, and the court finds that the juvenile needs secure custody for 24 hours to evaluate the need for medical or psychiatric treatment or to facilitate a reunion with a parent, guardian, or custodian. I say you shouldn't be appointed on undisciplined matters or on this specific type of issue. However, if you are involved with a youth that has interstate compact involved, that's one circumstance where you may be appointed here. So if you have a kid who has run from another state and is in North Carolina, you may see that issue crop up with this one. Those are similar in handling to adult extradition warrants. There are some differences to it, but they're similar enough that even your time frames are similar enough that you should be able to work your way through that based on what's in the extradition statutes. The 8th criteria, again, is very specific to undisciplined. Juvenile is alleged to be undisciplined and has willfully failed to appear in court after proper notice. In that case, the youth should not be held for more than 24 hours. I will tell you that we are seeing these cases turn into contempt issues where kids are being held in contempt for failing to appear in court. And so they are getting petitions for delinquency cases for contempt, and people are being appointed on those. But if it is just an undisciplined petition, you should not be appointed on that. So again, those were the main criteria. However, we do have some others for what happens after adjudication or if there's a probation violation or a post-release violation. So that's covered under, or at least partly under, 1903C. So following an adjudication, the court can enter a secure custody order pending disposition or a placement under 2506. There are limits on the time frame for this, and we'll discuss the time frames a little bit later, but you should know this should not be viewed as indefinite. You should not have a kid that gets placed in secure custody pending disposition and your disposition court date gets set out 30 days, 60 days, or more without a hearing. If there is a probation violation, secure custody may be ordered for a juvenile who is alleged to have committed a violation of probation or post-release supervision, but only if the kid is alleged to have committed acts that damage property or injure persons. So if you have a kid who has a disorderly conduct issue as their probation violation, they cussed at their teacher, they cussed at the school bus driver, and are getting ready to pick up a disorderly conduct petition while they're on probation, that's not grounds for secure custody because they haven't injured a person, they haven't damaged property. So make sure that you're making those arguments. If you have a kid that's being brought back for a probation violation, they can't just place them in secure custody because they violated probation. There has to be specific circumstances there. Same with post-release supervision. You have a kid who's gone to YDC, they're out on post-release supervision, they pick up a new charge, a disorderly conduct. They may ultimately end up going back to YDC because they have violated their post-release, but it shouldn't be grounds for secure custody on the front end. So going to the time frames now, how long can a child remain in secure custody? 7B 1906A covers most of that. No juvenile shall be held under a secure custody order for more than 5 days or an order for non-secure custody for 7 days without a hearing on the merits or an initial hearing to determine the need for continued custody. That initial hearing may not be continued or waived. So if you are unlucky enough to get that phone call to come to court at 9 o'clock on a Monday morning because you need to have a secure custody hearing and mom and dad are not present, you can't waive and you can't continue that hearing. You need to talk to the kid, find out if they've got contact information from mom or dad and see if you can get them there as quickly as possible and what time they can be there, if they were even noticed. Check with them for other family members and contact information for them, but you cannot walk into the courtroom and tell the judge, we're not asking for a secure custody hearing today. You may have to stand there and tell the judge, we don't have a parent or guardian that we can present to the court today, but you cannot waive or continue that hearing. You have to have it on the first day. So if secure custody was authorized under delegated authority, that actually is a little bit different. And the initial secure custody hearing has to occur on the day of the next regularly scheduled session of district court in the city or county where that order was entered, if that session is before 5 days is up. So you get a kid that's in secure custody over the weekend on delegated authority, which is where we usually see those, you're probably going to be having your hearing on Monday. If you don't have a juvenile session before that 5 days, you can have the hearing in the district where the order was entered. So for those of you who practice in multi-county districts, you can go to the county next door and say, hey, y'all have a juvenile session going on and we have this kid in secure custody. We need to have their secure custody hearing in that county. If that happens, the clerk has a process that they follow and they will bring a recording device and a disc, and they will come to the other county and pop everything into the appropriate equipment that is in the courtroom and record the hearing, and then take it back to the original county that issued the order. So again, on the timing, hearings on continued secure custody after that initial one are at no more than 10 days. Now, those hearings can be waived, but only with the juvenile's consent and for no more than 30 days. So if you have a kid who comes in and says, I'm willing to waive the hearing, I don't want another hearing, I don't want to go home, I'm mad at my mom and dad because they're the people who had me locked up. Maybe under those circumstances, you waive the next hearing. Not the first one, but the second one. Even at that point, you need to make sure that the kid understands you can't waive beyond 30 days, because if you waive beyond 30 days, your kid's being essentially held illegally at that point. The statute in this particular set of circumstances is very clear about the time frames. The waivers are to be orally through counsel at the hearing, or you can waive in writing, but again, you need to make sure it's not past the 30 days. If it's a non-secure custody situation, if you went to court and got your child ordered into non-secure custody as an alternative to secure custody, that next hearing has to be within 7 days. And it also has the requirement that it cannot be waived past 30 days after that. So you would have to have those every 30 days. A little bit of differences if your kid is 16 or 17 years old. So our Raise the Age youth are covered under 7B 1906B1. If they are charged with an A through G felony, their hearings after the initial hearing are at intervals of no more than 30 days. So now we've flipped it. If they're 16 or 17, those hearings can be 30 days. They can be waived, but again, only with the consent of the juvenile. How do you get yourself back to 10-day hearings on that? Well, you can request it. So upon request of the juvenile and for good cause shown, further hearings may occur at intervals of 10 days. Usually what happens here and what I'm arguing in the court here is I don't have discovery on this kid's case. I was just appointed. We need some additional time to investigate possible placements and family members, and we don't want this kid lingering in detention for all of these reasons. If there's a mental health need or if there's a school need, all of the different things that you can argue about the specific needs and what's in the best interest of your kid are going to need to be argued on this, because the judge can just say, I'm going to set it out 30 days, and good cause is not clearly defined in the statute. We don't have any case law yet on what qualifies as good cause for those hearings to occur at the 10-day intervals. I use the kid's age. If they just turned 16, say they were 15, and a day after they turn 16, they pick up a charge, and they're with a bunch of other kids who are older. I use that as a reason to argue this really should be 10-day intervals, because but for this kid's birthday falling where it did, we would be having these at 10-day intervals anyway. So there's a lot of things that you can argue at that point. Hopefully your DA will agree with you and agree to have those at 10-day intervals. But if they don't, you're entitled to make your arguments on that. 7B 1903C covers secure custody pending disposition or placement. This is the one we talked about a little bit earlier, where if your kid has been adjudicated and the judge wants to order secure custody pending disposition or placement, that is not an indefinite period of time. This has come up a handful of times over the last week with some cases that I've helped some other attorneys on. If a kid is ordered in secure custody at adjudication and pending disposition or placement, as long as that kid remains in secure custody, further hearings to determine the need for secure custody shall be held at intervals of no more than 10 calendar days. They can be waived for 30 days, but only with the consent of the juvenile, and again, in open court or in writing. This one trips up a lot of people because ADAs are arguing that we can hold them now because it's secure custody pending disposition. So we don't have to have that hearing. We can go up to 30 days because this isn't in 1906. It's not in 1905. It's in 1903C. So people are skipping over it and not recognizing that that's also part of this section. So make sure that if you have a kid who is ordered into secure custody as part of disposition, you're having those hearings. It comes up a lot with placement issues. If you're looking for placement for a kid that's been recommended for a PRTF, especially because those are so difficult to find, people want to set those out because they'll say, well, we can't find a placement faster than 30 days. So we need to set it at 30 days. If you set it at 30 days, your kid is going to linger in that detention facility because there's no sense of urgency to find that placement as fast as possible because you've given them 30 days instead of 10 days to find a placement. So do argue for your hearings at those 10-day intervals. So again, back to the raise the age youth, 7B 1906B2 and 2200.5D get read together. If you have a kid who has been sent up to Superior Court and they are being remanded back down, the hearing on the need for continued secure custody, the first one, has to be held within 10 days. After that, you fall back to your 30-day intervals, but the first one is 10 days, and that hearing cannot be waived or continued. Hopefully that is not happening in cases where kids are not in secure custody, where they've already been released or bonded out, but just know that that is something that's available, that the prosecutor can ask for secure custody on remand, and the judge can order it. So now that we've talked about all of the criteria, we're going to back up a step and talk about where is my client. So when you do get that phone call at 9 o'clock on Monday morning and you're scrambling trying to figure out where is my client, I've got a hearing now, they've set it at 2 o'clock because I said I couldn't be there at 9, I've got to find this kid. Where might they be? 1905 sets out the locations for secure or non-secure custody. So if your kid is placed in secure custody and they are under 18, they shall be held in a juvenile detention facility. If you need to locate that kid in a hurry, the easiest way to locate your client is to contact the local Department of Juvenile Justice because they're going to be the ones who are transporting, so they should know exactly where this kid is. Next step is calling the parent, guardian, or custodian. Hopefully they know where their kid has been placed. Sometimes they don't. Sometimes the kid has been picked up and placed in secure custody and mom and dad know they're in secure custody, but they don't know the name of the facility. If there was a withdrawal of prior counsel, you may be able to call that attorney and say, hey, can you tell me which facility is this kid in? They may be willing to speak to you, they may not. But my very first contact whenever I find out a kid is in secure custody and I'm looking for them is to call DJJ. I'm not sure if questions are flashing up because I can't actually see when I'm sharing my screen. So I should have paused for a breath and asked, are there questions?
None in the chat at the moment, Terry, but folks have put in the chat how long they've been practicing. So I have a good variety. A lot of folks that have been practicing for 19 years. Christian, 19 total, 15 years of prosecution, and then 4 years on the defense. Julie for 19, Star for 10 years of juvenile, 19 total. Amanda, 9 years of juvenile appeals, and Maggie Timothy, 10 years doing delinquency and parent defense.
Good. So mostly people have been practicing a long time. So y'all already know this then. So back to Where's My Client, there are 9 state detention facilities and 4 county operated detention facilities across the state. If you need to find exact contact information for the facility, if your court counselor didn't provide you a number, they just got in a hurry and said, here's where they're at, you can look at the DPS website. And I put the link in here. We'll share the PowerPoint with you as well so that you can find this information, but all of the contact persons and numbers are on there for each of the detention facilities. This link is directly to the ones for juvenile detention centers. So under 7B 1905C, if a kid is charged with an A through E felony, they can be held in a holdover facility for up to 72 hours if there's no other alternatives available and the protection of the public requires it. I have not seen this happen because most of the kids are in detention facilities and they're kind of scattered at this point since Jail North closed. Jail North being in Mecklenburg County, we've had a lot of kids sent pretty far away from home. One thing that I would tell people is that Department of Juvenile Justice has told me several different times, and Department of Public Safety has told me several times, they will honor orders that are entered by the court. So if you do have a kid who is placed in a detention facility pretty far away from their family members and they can't drive to visit, or if you need access as the attorney and you can't drive that far to visit because of your schedule, I've had a couple where orders have been entered directing that kids be moved from one detention facility to another that's closer. They are a little bit full. They are, in fact, overly full at this point. So it may not happen immediately, but you can ask for your kid to be moved to a facility that's closer. And again, most of the detention facilities are telling me that they will honor that request unless there's some glaring issue, like these kids are alleged to be members of a gang and they have assaulted each other and we don't want them in the same facility, but that takes a little bit of time to work out logistics. But for the most part, you can make that request and have a judge order it, and it should be honored. So if you have a kid who is charged after reaching the age of 18, they can be placed in the county jail. So even those kids who had a charge that they would have been 16 or 17 at the time of the offense, but they just didn't get picked up and arrested until they were 18, they can put them in the county jail because of sight and sound separation with youth and adults. Raise the age kids who are transferred remain in the detention facility, the juvenile detention facility, until they reach the age of 18. At that point, they can be transferred to the county jail. I put in this slide that they may be transferred to the county jail because I've had a couple of cases where people just sort of missed it and the kid stayed in the detention facility. But if it's caught, your kid is going to be moved to the county jail, if for no other reason because the detention facilities are overcrowded and the jails are not as overcrowded as the detention facilities are.
Hey, Terry, I have a question about that.
Yes, ma'am.
Sorry to interrupt. So, yes, welcome to my office. We have, Alexander was saying, like, continuing to hold juveniles after they turned 18, as opposed to sending them to the county jail. So, but I know that they're supposed to be transferred basically on their 18th birthday, because of that requirement, sight and sound. So is that just like an oversight, or is that an option?
I think it may be oversight, unless, and I will say this, if they haven't been transferred to Superior Court, they're still technically in juvenile delinquency court. Some of those kids are being kept in juvenile detention, and I'm not sure if that's a policy issue with DJJ and Department of Public Safety. But if they have been transferred to Superior Court, they reach the age of 18, they are supposed to be sent to the county jail.
Okay, thanks.
Hopefully that answers that. I know some detention facilities are doing some things a little bit different. So that brings us up to secure custody hearings. 7B-1906D covers the process and how this is supposed to work. If you're in your secure custody hearings, the first thing that I tell people is don't ignore reasonable factual basis to believe the facts alleged in the petition are true is the very first piece of it. Because the court shall receive testimony and allow the juvenile parent, guardian, custodian the opportunity to present evidence and examine witnesses and be heard on their own behalf. That's part of that reasonable factual basis to believe the facts alleged in the petition are true. You can be heard on that. I'm not going to put my kid on the stand in a secure custody hearing for them to talk about the facts of the case. But if I've got a parent who says, my kid was at home asleep whenever this happened, I might put them up. The court is not bound by the usual rules of evidence, so they are going to hear hearsay evidence, and they are going to hear an officer say, we interviewed this witness and they told us XYZ. But that said, the state bears the burden at every stage of the proceeding to provide clear and convincing evidence that restraints on the juvenile's liberty are necessary and no less intrusive alternative will suffice. Now, I've bolded, underlined, and used a little bit of color here because the burden actually is on the state. And they have to do more than just stand there and read the petition into the record and tell the judge, okay, reasonable factual basis, because here's what the petition says. No, you have to put up some evidence so that a judge can make findings. And the burden is clear and convincing evidence at this stage. Then the other thing that you need to be arguing is that not only is it the state's burden to prove that there's a reasonable factual basis to believe that the kid committed the acts alleged in the petition and that the kid meets one of those statutory criteria, they also have to prove by clear and convincing evidence that secure custody is necessary and there is no less intrusive alternative. This is the piece where you can put your kids' parents on the stand and say, we came up with a safety plan. You should be coming up with a safety plan. Here are all the things that we're going to do to make sure that this kid comes to court and that there are no further issues that the court needs to be worried about. We're going to have mom watching the kid during the day. Dad's going to be watching during the night. If both parents are unavailable due to work, we have aunt over here who is willing to come and bridge that gap. Lots of opportunities here to put up family members, but talk to those family members before you put them on the stand, because what you don't want to do is rely on your kid who said, my mom and dad want me home and they're willing to do all of these things. You start calling those people as witnesses and mom gets on the stand and the very first thing out of her mouth is, I don't want them home right now. So do talk to those witnesses before you're putting them on the stand, because I've seen a couple of situations where attorneys have called the parent thinking that they were going to say, yes, I want my kid home. And then the parent said the exact opposite. You can't control it if they blindside you and tell you one thing and then say something different on the stand, but at least do have that conversation before you're calling them as a witness. So the secure custody hearings, the court has options, and you need to remind the judge that the judge has options. They don't have to hold this kid in secure custody. They can release on written promise of the parent, guardian, or custodian to produce the juvenile for court proceedings. I don't ever see our judges do this. I don't ever see anybody really ask for it. People forget that you can literally ask the parent to sign a written promise to appear and to bring the child to court. You can release to a responsible person or organization. So that's usually where I'm arguing for non-secure custody. But if there is a placement that has become available and the kid has been accepted to it, you can argue for release to that placement. Release on conditions and restrictions that are reasonably related to securing a court appearance. Electronic monitoring. Mom and dad are separated. The kid listens to dad better than he listens to mom. Maybe the kid goes to stay with dad for at least the period of time while we're waiting for this case to be resolved. Placement with a grandparent that the child has a close relationship with and is less likely to run. There's a lot of different things that you can argue on any conditions that are reasonably related to securing a court appearance. And then the fourth one, which really truly is a catch-all, release with any other conditions related to securing the juvenile's presence in court. You've got a lot of wiggle room there to be making arguments and creative arguments to a judge about, here are all the things that are alternatives, less restrictive alternatives to secure custody: electronic monitoring, house arrest, regular meetings with a court counselor. There's a number of different things that you can ask for here that, again, go into being prepared and making your own safety plan that you can present to the court. Written safety plans that you can actually put into the court record are even better if you can get that much contact with the juvenile and the juvenile's family. So secure custody orders, once the judge does order secure custody, and we always hope that they don't, but when they do, those have to be in writing with appropriate findings of fact. And again, this is in 7B 1906G. Use that to argue to your judges that they have to actually have hearings and insist on testimony instead of the prosecutor just reading the petitions or even a portion of the discovery that may or may not have been made available to you. Again, rules of evidence are not followed closely and are not necessary in secure custody hearings, but I do object to speculation and conjecture by the ADAs, law enforcement officers, and court counselors, especially when they're saying things like, we don't think they're going to show up. You don't know they're not going to show up. You're just guessing. You're speculating. You think that they might not show up. You think they might get into more trouble, but they might not. Remind the ADAs and the court of the presumption of innocence and the purpose of juvenile court. And the purpose of juvenile court is not, let's just punish this kid and treat them the same way we would as an adult. It's right there in the statute. We are looking at the needs and best interest of this kid. So again, going back to the order itself, once that's done, the findings have to include the evidence that the judge relied on. There's again your reason why you have to have testimony. What did the judge rely on to make those findings? And they also have to include the evidence that they relied upon in reaching that decision and the purpose which continued secure custody is to achieve. So if the only purpose is to make sure this kid comes to court and you've got mom and dad saying, we're going to bring them to court, and a kid that's never missed a court date before and a parent who's never missed a court date before, secure custody is not necessary under those circumstances. You can ask the judge to enter an order and ask for those specific findings and what purpose is secure custody achieving with this specific youth. Hold the judge to that standard and remind them this is what the statute requires you to put in your secure custody orders. So talking a little bit now about restraints in court. If you are in a secure custody hearing, 99% of the time, your kid is coming to court in shackles and chains. They're going to be led into a back room somewhere, hopefully, and they're going to be seated while they wait for their case to be called into the courtroom. But there are some counties where that's not what happens. They're brought into the courtroom in shackles and chains, and they're either seated in the jury box or they're seated on a pew or a row of seats right behind the DA or right behind where the defense attorney sits. That is not what is supposed to be happening. So at any hearing, not just secure custody hearings, but we're talking primarily about secure custody hearings for these purposes, the court may order physical restraints in the courtroom, but only under certain circumstances. And those circumstances are that the judge finds restraints are necessary to maintain order, to prevent the juvenile's escape, or to provide for the safety of the courtroom. My DA loves to argue, we're in a teeny tiny little courtroom and we only have one bailiff and there are multiple points of ingress and egress from the courtroom. This kid could jump up and run out of any one of those 3 doors. My counter to that is, this kid is 12 years old. His mom and dad are seated right here behind him, and those multiple points of ingress and egress include a door that is literally right behind the judge. He would have to clear a podium in order to get out of that door. The other door is locked, so he'd have to run to it and unlock it and be fast enough to do that to avoid the 2 bailiffs who were in the courtroom and the 4 court counselors who were seated behind him. Make those arguments for removal of the restraints and point out to the judge the restraints are not necessary. You don't need to have a kid come into the courtroom with their hands handcuffed, a waist chain, and all of those connected down another chain to their ankles where their ankles are shackled in order to maintain order and prevent the juvenile's escape and provide for safety of the courtroom. You have a bailiff in the courtroom for a reason. You have court counselors in the courtroom for a reason. All of that other stuff is just frankly unnecessary. And as far as maintaining order, it's more disruptive to the court when a kid is brought into the courtroom in shackles and chains and they know half the people in the courtroom and half those people are pointing and laughing. The other half the people are crying because they're seeing their child led into the courtroom, shackled and chained like an animal. Make those arguments and ask for the restraints to be removed. And you need to ask for those restraints to be removed before your kid is brought into the courtroom, because once they're in there, it's defeated the whole purpose of the statute. You need to be asking for that to happen first, and then your kid can be brought into the courtroom. And again, it's on the slide. It's literally in the statute, 7B 2402.1. The juvenile and the juvenile's attorney shall be provided an opportunity to be heard to contest the use of restraints before the court orders the restraints. The presumption is in favor of no restraints. You read that statute closely. At any hearing, the court may order restraints, but only when. So ideally, what should be happening is that the kid should be being brought into the courtroom without any restraints unless somebody asks for it. There is an American Bar Association resolution against the use of restraints, and it addresses specifically the prejudicial impact on the client. And it speaks to things like, if you have an adult who is going to trial in superior court and they're in custody, they haven't been able to make bond, you go buy them clothes and you ask for the restraints to be removed, because you don't want that person in front of a jury in shackles and chains and stripes or an orange jumpsuit. So when you're in juvenile court, that set of circumstances is no different. The ABA resolution actually speaks to that issue and talks about judges are people too. We look at it differently because in superior court, these adults get jury trials. But the prejudicial impact to a kid with a judge still exists. You still have a judge who is seeing this kid for the very first time brought in a jumpsuit and flip-flops and chained from one end of their body to the other. And that's going to be their first impression of that child before they have a secure custody hearing, or before they have a probable cause hearing, or before they have a transfer hearing. And that's certainly not fair to that kid, because it's still going to be in the judge's mind. That's, whether they want it to be there or not, it's there. And a lot of judges were actually talked to as part of that American Bar Association resolution. I've included a link in it in the resources at the end so that you can print that for yourself and actually take it to court with you if you want to show it to your judges as part of your argument. But there are a lot of good reasons why kids should not be in restraints, not the least of which is the impact that it has on their mental health. So make sure you're making these arguments in any secure custody hearing, that you are not allowing your kid to be brought in restraints without making those arguments. If you do have a situation where restraints are going to be requested by the prosecutor, or you're going to just have to have a hearing in general because the court counsels are asking for it, you need to utilize the statute 7B 2402 on open hearings to close the courtroom. All hearings are open to the public, but may be closed upon a motion of the party or the court's own motion. And the court is required in those circumstances to consider the nature of the allegations against the juvenile, the age and maturity of the juvenile, and the benefit to the juvenile of confidentiality. And that one is the one that I usually argue when I'm asking for a closed courtroom, because either we're having a restraint hearing or restraints have already been ordered, and I don't want this child brought into the courtroom in front of everybody in restraints. Again, number 4, the benefit to the public of an open hearing, and 5, the extent to which confidentiality will be compromised. You may have a room full of kids who know that particular client of yours because they went to school with them or they're related to them, or it's a small county and everybody just knows everybody. They may not pay a whole lot of attention to somebody who just happens to be there like them, but they're going to sit up and pay attention if your kid has walked into the courtroom in shackles and chains. So do be asking for those hearings to be closed. Preferably you're asking for the hearing to be closed before you even address the issue of shackling. But if shackles have already been ordered, at a bare minimum, ask to close the courtroom after that. One thing that I will say on this, if we are not best interest attorneys, but we're expressed interest attorneys, and I've talked a lot about make sure you're asking for shackles to be removed and make sure you're asking for the hearing to be closed. You do have to talk to your client about those issues. I have had a kid who was shackled and chained, and mom was the alleged victim in the crime that got petitions filed in the first place. That kid didn't want his restraints removed. He was mad. He wanted his mom to see what she had done to him. A little bit of a weird situation. So we didn't ask to remove the shackles because the kid said, I want her to see what she did to me. I need her to see that I didn't just go for a little vacation and I didn't just go to a summer camp. I went to jail because she asked for them to take me to jail. And it actually worked. She was very upset and wanted the case dropped after that point because she didn't really realize that juvenile was as serious as adult cases are in certain circumstances. So do be aware that you need to talk to your kid about all of these things before you do them. So you need to tell them they have a right to have a restraint hearing and that you're inclined to be asking for the restraints to be removed, and that they have a right to have the hearing open, but they can also ask for it to be closed, and that the judge would have to make certain findings in order to close the courtroom. So do be asking for all of those things with your client's understanding and their consent to that. So we're a little ahead of time, but that brings us to our resources page. Again, you'll get copies of the PowerPoint, the Juvenile Defender website, our website, OJD's website. I've included that on here because we have a lot of resources available to you, motions and things that hopefully you're looking at and using on a regular basis. The ABA resolution that I mentioned is the second link, or I'm sorry, the third link on here. It's very detailed, and again, I printed it so that I could take it to court with me and argue that with our judges. And then obviously the DPS website so that you can locate detention facilities, but they also have some additional information on their website about use of restraints and other types of issues that relate to our youth. So don't just look at where are the detention facilities. You can actually look at that and get some statistics and things that are helpful for court arguments as well, including arguments about secure custody and racial demographics. So do be looking at that as well. If you're in a county where you're seeing a lot of issues with it's only Black youth who are being placed in secure custody, you need to be talking about that in the courtroom. You need to be raising that issue and not letting people slide. Hold them accountable and make sure you're making those arguments and making people aware. Maybe they're not aware that that's what they're doing, but once you've addressed it and started making those arguments, hopefully that will generate change and people thinking about, let's look at these numbers. That attorney's right. We are only using this in this set of circumstances, and it may make the judges sit up and pay a little bit more attention, because if your county is like mine and the judges rotate and they're only in juvenile court once a month, they may not be paying attention to it because they might only see one kid in detention every month, if even that. So do look at those racial demographics and breakdowns and make those arguments as well when you're considering secure custody arguments. And that brings us to here's our team. You've probably met most of us before. So I'm going to skip over that and bring you to our contact information, our website link. We are on Facebook and LinkedIn. We do have a YouTube page as well. I didn't put that on here, but we have that as available as well. So I'm again a little bit early on this. So if there are questions or people just want to share their stories, we are happy to hear either.
This is Tim Dunn from Cumberland County. I've got some great stories in Cumberland County, but I tell you, it would take another hour to tell you. So if anybody wants to talk about an interesting juvenile justice system in court, just give me a call or email and I'll be glad to talk to you. Thanks for all that you all do up there. Talk to you soon. Have a great weekend.
Marsha, that's all you.
Hey Tim, Tim's right. They've got some interesting things going on down there in Cumberland. For sure, it's good to see you, Tim. Oh look, we're in the same room.
So I see a lot of familiar names, and most of you probably already know this, but I am the contact person for the Western counties, and Bersha is the contact for the Central. So there you did I say it right? Are you Central or are you Eastern? I keep mixing them up.
I'm Central. Eric gets the beach. He well, I guess Kim picked it for him when she did it, but he gets the beach counties. That's the boss privileges.
Wait, so Rocky Mount's in the beach now?
You get all of the beach counties. They're not all beach counties, but you.
No, you have. I think you have some too. You know, it's okay.
I think I get one. Hey, Brandon.
Hi. Brandon, you may be muted.
There you go. Can you hear me now?
Yes, we can hear you now.
All right. How you guys doing?
Good. How are you?
Good. Make sure I don't get any credit because I didn't show up the whole time. I got stuck in a meeting after court. I had court this morning. But I wanted to show up and show my face to everybody. I am at the beach, Eric. And I'm going to go down to Dare County tomorrow. I'll be thinking about you.
So one thing very quickly that I did not address because we were very focused on secure custody prior to adjudication and prior to disposition is if you have gotten to disposition, secure custody and intermittent confinement. We did have some questions about that this past week. It is possible for judges to order intermittent confinement, but they have to be very specific. They have to set out the time frame when the kid's going in, when they're getting out. They cannot delegate that authority to the juvenile court counselors to say, oh, if this kid misbehaves between now and, 6 months, whenever probation is up, I'm delegating the authority to the court counselor to go ahead and put this kid in detention for 2 days or 14 days. They can't give them that authority. There has to be a very specific, clear order as far as that goes.
So I actually have a question because this is a new one for me. Most of my kids want to get the hell out of custody. Okay. So of course, I always get the special things. So I have a juvenile charged with murder and he wants to stay in custody. And he does not want to be brought to court because his mother will be there and she's interesting. And every time he's brought to court, she asks the judge if she can hug him and things like that. Now, he looks about as comfortable as if he was licking a skunk when she hugs him. And so he wants to waive the 30 days. He wants to waive 10 days. He does not want to come to court until we absolutely have to. And can I do that without him coming to court?
You can't waive past 30 days based on the statute, but I have had that exact same type of issue crop up with another kid. And what we did was we actually used WebEx, which I hate using in court situations, but we used that to be able to say, here's the kid, I'm as attorney waiving this hearing for another 30 days. A couple of times during COVID when we couldn't get the technology working, I did do a written waiver and handed that up as well. So that's an option.
Okay, so yeah, I think WebEx would be a decent option, even though I don't know if Stokes County has internet. I am starting to think not, but so yeah, thank you, because yeah, no.
That's going to be my new go-to phrase when describing people's comfort levels now. On a scale of 1 to licking a skunk, where are you?
I just want to point out that for those of you who know me well, I have not said a bad word on video yet today. So you should be happy I said licking a skunk.
I enjoy that. I thought it was colorful and descriptive.
Julie, we lick skunks in Cumberland County all the time, so I want to hear that other vocabulary you have. Come on down to Fayetteville and that you can share with this old Marine what you would really say.
Well, my granddad was a Marine in World War II, so he taught me all the good words from an early age.
Thank you all for attending. I have dropped the link to our evaluation in the chat, and I'm going to just put it again just in case. If you all just don't mind filling that out for us, it just helps us make these trainings better as we go on. But before I close this out, any last minute questions for Terri or for the team? Yes, we have. I think you may be on mute, Michelle.
I hit unmute, sorry. I think you said this already, but are you going to share the PowerPoint?
Yes, yeah, but we'll send it out right after the presentation.
Thank you.
All right, well, that will end us. Thank you all so much for joining us on this Friday afternoon. We will have a training next month. It will be about military collateral consequences when it comes to youth with juvenile records and criminal records as well. So we hope you join us for that. Thank you all. Have a good day.
Thank you so much. See you, everyone.